We are ready to begin.
Thank you. Good afternoon, ladies and gentlemen. I want to welcome you to today's Cannabis Regulation Commission meeting. It's Thursday, April 28th, 2022. The time now is 2:07 p.m. I'm President Robert Ahn. I'll be chairing this meeting. The following commissioners have also joined this meeting virtually via Zoom. We have Commissioners Vice President Mason, Naro, and Commissioner Villa. DCR's Acting Executive Director Michelle Grakian has also joined this meeting, along with members of the department and the City Attorney's Office. Before we begin, I'm going to go over some general rules of today's hearing. Due to the COVID-19 pandemic, this meeting is being conducted virtually via Zoom and is being live streamed on the DCR's website. Those who wish to watch this meeting can do so by visiting cannabis.lacity.org and clicking the About menu on the top. Under the About menu, click the Commission Meetings link. Scroll down to the bottom of the Commission's Meetings page to find the live stream. Folks can also listen to this meeting by calling council phone at 213-621-2489 or 818-904-9450 and selecting the number for this meeting. Members of the public who want to offer public comment may call one of the two toll-free numbers 877-853-5257 or 888-475-4499. Enter meeting ID 860-838-7310. These numbers can also be found on the agenda. Agendas for today's meeting can be found on the department's website at cannabis.lacity.org and navigating to the commission page under the About menu. This meeting is being recorded. Therefore, we ask all speakers to please state your name clearly before you speak. The audio file will be posted online within 48 hours of the meeting. If you're on the Zoom call, when the item you wish to speak on is called, press star 9 to get on the speaking queue. We will then call out each speaker by the last 4 digits to identify the caller. The caller will be prompted to unmute themselves by dialing star 6. If there are no other items you wish to speak on, you may disconnect from this call and view the meeting via the live stream or dial council phone to listen only. We will be following the agenda order today. The presentation today to the commission will be available on the department's website within 2 business days from this meeting. We will consider general public and single or multiple agenda items together. Therefore, speakers will have 1 minute for general public comment and 1 minute per item, with a maximum of 2 minutes for multiple items. Please state whether you are providing general comment and or which other items or item they are speaking on before they begin to comment, so that staff can appropriately time. If the speaker does not specify which items they are speaking on, 1 minute will be provided. Now, moving on to general public comment and single or multiple agenda items, we'll now open that portion of today's proceedings. Speakers can address the commission on non-agenda related items that are within the jurisdiction of the commission or provide public comment for items in today's agenda by dialing star 9 on your telephone. If you're listening on the live stream and have called to provide public comment, please mute the live stream audio to eliminate feedback. Commissioners and staff, please mute your microphones. Ms. Treviso, please call the first speaker. Ms.
If
Treviso?
anyone wishes to provide public comment, please dial star 9. Caller with phone number ending in 5009. Please state your name and the items you wish to speak on.
Hello? Hello?
Yes, please state your name and the items you wish to speak on.
My name is Andrea Caswell. I would like to speak on Round 3, Phase 2.
Sure.
And, okay, I would like to know when Round 3, Phase 2 would start. And also, we were promised to have our fees waived I haven't heard anything about that recently. So those are my only two comments. I just want to know when round 3, phase 2 would start, the lottery would start, and when will we have our fees, licensing fees waived? Thank you.
Thank you. If anyone wishes to provide public comment, please dial *9. Caller with phone number ending in 3846, please state your name and the items you wish to speak on.
Hi, my name is Naruth, and I'm calling about number 4 licensing report for the DCR meeting.
Sure, you have 1 minute.
Okay, cool. I wanted to know where the city or DCR was in terms of incorporating CEQA, CEQA requirements for annual and annual and new licensees. That is all.
Thank you. If anyone wishes to provide public comment, please dial *9. President On, I don't see any more raised hands in the queue.
Let's give it a brief moment more. Okay, I don't think we have any other speakers. With that, I'm going to go ahead and close both the general public comment and the single or multiple agenda item periods. And let's move forward to item number 1 of our agenda. Commissioners, you should have the advanced calendar in front of you with our future meeting dates. Please take a look and advise of any planned absences. Okay, seeing none, let's move on to the approval of the minutes. We were sent the minutes of April 7th, 2022 for review. Do I have a motion to approve those minutes?
This is Commissioner Villa, and I move to approve the minutes of the April 7th meeting.
Thank you, Commissioner Villa. We have a motion. Do we have a second?
So Commissioner Naro, I second the motion.
Okay, we have a second from Commissioner Naro. Ms. Treviso, please call the roll.
Commissioner Villa, how do you vote?
Vote aye.
Commissioner Narl, how do you vote?
Aye.
Vice President Mason, how do you vote?
Aye.
President On, how do you vote?
Abstain.
The vote is 3-0 and the motion passes.
Thank you. Next, moving on to commission announcements and updates. Commissioners, do we have any announcements and updates at this time? All right, let's move on to future agenda requests. Commissioners, are there any future agenda requests? Okay, seeing none, let's move on to item number 2. Moving on to item number 2, it's a finding to continue teleconference meetings pursuant to AB 361, which requires that all legislative bodies make findings concerning the state of emergency stemming from the COVID-19 pandemic to continue holding virtual meetings. Can I get a motion to approve and continue teleconference meetings pursuant to AB 361?
This is Commissioner Villa. I move that the commission determine in accordance with AB 361, Section 3E3, that this legislative body has considered the circumstances of the state of emergency and that the state of emergency continues to directly impact the ability of the members to meet safely in person, and/or state or local officials continue to impose or recommend measures to promote social distancing.
Thank you. Do we have a second?
So Commissioner Nardo, I second the motion.
Great. Mr. Vizo, please call the roll.
Commissioner Villa, how do you vote?
I vote aye.
Commissioner Naro, how do you vote?
Aye.
Vice President Mason, how do you vote?
Aye.
President On, how do you vote?
Aye.
The vote is 4-0 and the motion passes.
Thank you. Now, moving on to item number 3, this is the report from the Acting Executive Director, Michelle Garakian. Ms. Garakian, first of all, I want to just welcome you. This is your first commission hearing as the new Acting Executive Director. I just want to welcome you and also congratulate you. We're very excited to have you.
Thank you, President On. I appreciate that. Welcome. I'm going to jump right into it. Thank you very much, everybody, for being here today. Thank you to my staff. Thank you for the folks that joined us. A special thanks to our commissioners who continue to show up, do the work, and provide us with the assistance we need to be more effective. My name is Michelle Garakian. I'm currently serving as the Acting Executive Director of the City of Los Angeles Department of Cannabis Regulation. Today marks my first Cannabis Commission meeting serving in the executive role. As this commission knows, in LA, we have one of the largest cannabis markets in the country. To date, DCR has issued more than 12,000 licenses, with more than 350, 105 of which are retail and non-retail storefront granted to social equity applicants across all licensing activities. 290 of those businesses are licensed by the Department of Cannabis Regulation to engage in retail and non-storefront retail commercial cannabis activity. 105 of the 290, which represents about 36.2%, are social equity businesses. That's huge. And we hope to increase that so that more than half of our licensed businesses are going to be social equity applicants over the next year. The number of social equity retail licenses issued by the City of Los Angeles exceeds the combined totals of social equity retail licenses issued by most other California local jurisdictions. But there is more to do. Over the next 8 months, I will work with DCR and our staff to focus on striving to meet the following goals: updating our licensing processes based on recently adopted ordinance and revised rules and regulations, which will be discussed at large today by Jason Killeen. Transitioning existing licensees into the environmental review process so the department may administer the annual licensing process later this year. Expediting the review and issuance of temporary approval to eligible applicants. Making effective and frequent updates to the DCR licensing portal and our website. Further, DCR will host more events detailing additional information. We'll be making staff more available to our stakeholders. In fact, in consideration of recent feedback, we're going to be kicking off a new monthly event in May, on May 3rd, a Q&R webinar luncheon with Jason Killeen, our AD over licensing. This is going to be an hour-long Q&A virtual lunch hour webinar with Jason, where he is going to be receiving and answering all your questions. We just sent a blast about this around yesterday, and we've already received 50 RSVPs. I'm also going to be focusing on developing and opening up the social equity individual applicant verification process, which is a prerequisite to Phase 3 Retail Round 2 lottery. We aim to announce the opening of this verification process in early May, likely next week, and open up the verification process in late May. Staying in theme with more events, more information, we'll be hosting 2 webinars in May prior to the verification process opening up to help guide prospective candidates through the process, and several throughout the summer when the process is open, as well as office hours for applicants looking to get verified, so they may discuss with DCR which documents and other items may qualify them for verification. Lastly, we hope to open up phase 3 retail round 2 lottery in late 2022 following a successful verification process. DCR has spent a lot of time over the year listening to feedback of our stakeholders and working doggedly to try and make the process, the licensing process that is, less bureaucratic and more business friendly. DCR is pivoting to become more customer service oriented while continuing to center social equity at everything we do. To that end, I plan to communicate to the folks in our universe. The department has had its fair share of tribulations, and I'm looking forward to changing the narrative. Some of these examples include pushing up more frequent updates through our portal and the website. One of these ideas ostensibly we're looking at is potentially an RSS feed on various web pages so that when there are changes or forms uploaded to a web page, folks will get notification, and we're still in the process of reviewing if we can do that. We're going to be bolstering our communication to a broader audience and what we're doing and about what we're doing through proactive media outreach, our quarterly news bulletin, our quarterly council reports, and various DCR publications such as the Cannabis Dispatch, which is a social equity program monthly newsletter that launched in January 2022. We're going to be doing more BLC programming, more licensing webinars, and other pilot events such as the Q&A virtual lunch hour with Jason. I continue to plan on engaging with our communities. For example, our Spark project, which allowed community members to provide feedback to DCR, has proven to be very helpful, and as well as meeting quarterly with key stakeholders, social equity, public health, and trade organizations to learn about their concerns and how we can work collaboratively to address that. I also plan on continuing to build on CAT's mission, and will be focused on making sure social equity is at the center of our strategies and policy reforms, fine-tuning to ensure our processes are running smoothly, and widening access to services and programs via the BLC program, and working with our state partners on policy reform around equity applicants and local funding allocation. I also plan on significantly growing the local commercial cannabis tax base by improving processing timelines, moving applicants through our local processes more efficiently, which will grow our local industry and subsequently the local tax base. In tax revenue alone, licensed commercial cannabis businesses have generated more than $320 million since 2018. And this fiscal year alone, DCR expects more than $100 million in tax revenue. Next up, we're going to hear from Assistant Executive Director Jason Killeen, who will address our recent amendments to our ordinance, as well as our updated rules and regs. He'll also spend time going over key aspects of our licensing process, including DCR's newly revised forms and workflows and other important efficiencies that will make this process easier for applicants, licensees, and prospective applicants. Further, he will address important dates, timelines, and programs that will be vital to the universe, the folks in our universe over the next 8 months. Items that were addressed in public comment today will be addressed during his portion of the presentation, so we hope folks will stay on to learn more. And to that end, my presentation is complete. President On.
Okay,
Welcome
great.
any questions.
Yeah, thank you, Ms. Grakian. At this point, I want to open it up to my fellow commissioners for any questions, comments, or other deliberations. Commissioner Naro.
Yes, hi, thank you. Welcome to your new role. There was a comment, a public comment. I think you answered the question about the lottery, but I think they had another question I'm trying to recollect. But I just want to make sure you addressed that question that came out in the public comment. I forgot the call. I think you addressed the question about the lottery, the date, but I think he raised it. I think it was about fee waivers or something.
Yeah, Jason will address that later on in his presentation.
Okay, thank you.
Yeah,
Thank you.
I just want to make sure folks stay on for that. Be chock full of information. Thanks, Commissioner Naro.
All right, Vice President Mason.
Good afternoon, General Manager, Acting General Manager Garakian. Welcome to your role. And you have set quite an ambitious agenda for yourself. I especially applaud the desire to make sure that half of the city's licensees are social equity licensees. Long overdue, long overdue. So it will be amazing to see that happen. I'm seeing some of the work that currently existing dispensaries that are social equity dispensaries are doing in their community, then it's very encouraging. So thank you for that goal, and we are here to support you.
Thank you so much, Vice President Mason. I thoroughly enjoy us being able to communicate conveniently to learn more about the challenges that you're hearing about as well.
Great. Anything else? Commissioner Villa, do you have any comments?
Thank you. I have no comments at this time.
Okay, thank you. Well, before I let you go, once again, welcome, Ms. Garakian. We really look forward to working with you and let us know how we can support you.
Certainly. Thank you, sir.
All
Thank
right.
you all.
Okay, let's move on to item number 4. This is the licensing report. Mr. Clean.
Good afternoon, President On,
Good
Commissioners.
afternoon. Whenever you're ready.
Thank you. Next slide, please. So I just wanted to start today's presentation with dispelling a few of the misconceptions about our process. A lot of concerns have been raised about the application process becoming more difficult and challenging over time, and that couldn't be farther from the truth. We've made substantial progress and improvements every single year that we have been in authorization and working directly with the City Council and the Mayor's Office. Under original law back in 2018, only phase 1 applicants had access to temporary approval. In 2019, that was expanded to include phase 2 applicants. And then in 2020, it was expanded to include all applicants, including the social equity applicants that applied through phase 3 retail round 1, as well as through the phase 3 general processing. Additionally, DCR has pushed very hard to streamline the temporary approval application process. Originally, folks had to meet requirements as stated in the code and in the rules and regulations, but there weren't forms or documents to achieve those goals. So we got documents and information in a variety of ways, which made processing those records a little bit more challenging because we had to identify how on those documents they met the requirements. So to help facilitate an efficient collection of information and data, we created the forms. And, you know, Rocky Wiles gets a lot of credit for coming in 2019 and getting the department to start adopting various forms to start collecting that information in a more efficient manner. Next slide, please. As I mentioned, you know, DCR has created dedicated forms to capture required information consistent with the manner in which it's listed in the municipal code. We've also streamlined our document review process and removed requirements which were unnecessary in over 90% of applications. For instance, we no longer require a premises diagram for pre-application review. We do not require site plans. For pre-app review, all we require now is a landowner attestation. And based on the recent municipal code amendments, we're only requiring that to be signed by the landowner and no longer has to be notarized. So we're always looking for ways to make the process more efficient and reflective of the information and data that we need in order to determine whether or not an applicant is eligible to receive a temporary license. We've also broken up our licensure process. As I mentioned before, other than phase 1 applicants who had access to temporary approval, everybody else was originally supposed to go through the full annual licensure process, which would have taken years. That process has been broken up into smaller segments. First, we broke it up into a temporary approval process and an annual application process. Then we broke it up even further so that folks could vet whether or not their proposed business premises location was eligible for further processing and even compliant before they actually executed a lease to present an application to the department. So now we have a pre-application review process We have a temporary approval application review process. We have an environmental review process, and then we have our annual application process. Overall, our process today is simpler, faster, less cumbersome, and less expensive than it was in 2018, 2019, or 2020. Next slide, please. Now I'm just going to hop into our standard licensing data. Currently, we have almost 1,200 business premises in our pipeline. 691 have received temporary approval for one or more activities. We have an additional 441 businesses in our temporary approval pipeline, of which 138 of the businesses have a status of local compliance underway, which means that their temporary approval application has been deemed filed. They've submitted all the documents, information, and forms to move forward. And we have another 303 who have not met the filing requirements. We also have 55 businesses in our pre-application review process. 32 of those businesses have received their status of eligible for further processing, which means that they have up to 1 year to submit their temporary approval application to the department. And that was created to give folks the opportunity to vet a location before they made material business decisions that were required to move forward in the temporary approval application process. Next slide, please. Here is a slide that some of the commissioners may be familiar with. Originally, we did provide licensing data by phase, kind of broken down between retail licenses and non-retail licenses. Because the number of licenses is very similar to the number of businesses in our pipeline, we had stopped presenting this data for a few months, but I'm happy to bring it back to the table. So in total, there are 1,440 different temporary approval licenses across the 691 authorized businesses citywide. And the majority of those licenses, of course, are associated with phase 1 and phase 2 businesses. And we hope to see additional phase 3 round 1, social equity phase 3, and general phase 3 businesses receiving licenses over the next 6 to 12 months as we have implemented new processes to make our process more timely and efficient and accountable. Next slide, please. Before I hop into this slide, I did want to just reiterate something that the director mentioned during her presentation. Of the 296 retail licenses the city has issued, which covers both retail storefront and non-storefront delivery, 106 of those licenses have been issued to social equity businesses. When we started, there were 0 social equity businesses in the city. Now, social equity businesses, at least for the retail category, make up almost 36% of the licensed businesses. And as the director mentioned, our goal is to improve those numbers, and we hope to achieve a 50-50 ratio within the next 6 to 12 months. But by the end of next fiscal year, we look to see over 50% of our licensed retail businesses are social equity businesses, and that is our commitment. Now quickly hopping into the mayor's proposed budget, which was released last week, to explain how we're going to hit all of the aggressive milestones and processing targets that we have before us. 9 of the interim positions that were adopted in February went before the Civil Service Commission earlier today. And we anticipate that the personnel department will notify us that the positions have been allocated and we can begin the hiring process next Monday. So we're already working with our liaison over at the personnel department to begin the request to certify those lists so we can start that hiring process as soon as possible. We do hope to be able to conduct those interviews sometime in May and then make job offers. And then folks will hopefully either start with the department towards the end of June or in early July. But licensing is a commitment for us, and we are prioritizing those new licensing positions to help facilitate moving folks through the environmental review process, and then of course the transition to the annual application process. Some of the key budget items that were included, the proposed budget continues the 37 position authorities that we've had for the last couple of years. Due to the pandemic, we weren't able to get additional positions, but the council did allow us to get 21 additional interim positions earlier this year, which we're in the process of getting allocated. Those 21 positions are also included in the proposed budget. In total, DCR will have 58 positions next year that will be able to provide a variety of services. Additionally, the proposed budget includes 3 additional city attorney positions, 2 attorneys, and 1 paralegal. All 3 of those resources will directly support DCR. Knowing that we're going into the environmental review process, there will be upcoming community meetings. There's going to be additional commission meetings. We're going to be taking public comment. We're going to be out there, moving records forward so that they can be presented for annual licensure. It was important to make sure that the city attorney team was beefed up so that they can continue to support us because we work hand in hand with them every single day. Additionally, there were 2 new finance customer service specialist positions that were added. Finance is in the process of filling those positions, and that will represent a 33% increase in customer support staff at their cannabis unit public counter. So we understand that folks have been frustrated with the lack of appointments and how long it takes to process payments. Finance is addressing that through these new positions, and hopefully folks will see improved processing times in the very near future. Additionally, we're happy to report that the mayor included the 3rd year of the $9 million commitment to the social equity program. $3 million was allocated to the unappropriated balance to support the business licensing and compliance components of the social equity program that are administered by Dr. Brown. So we were very happy to see that included in our proposed budget. Next slide, please. Now I'm just going to hop into a summary of the ordinance amendments. The key amendments are being presented here. These are things that are relevant to the commission and kind of how we present information to the commission. Over the next several slides, we'll go through amendments to the definition of owner and primary personnel, the new processing timelines for applicants in DCR to ensure that applications are processed towards licensure in a timely manner, as well as the new refiling process that opened last week. And then the creation of a standalone social equity applicant entity verification process that folks will be able to request upon completion of the pre-application review. That new process will allow for folks to vet their business entity before they submit their temporary approval application. Hopefully bringing this process up forward will allow social equity applicants to establish the legal entity that they wish to pursue licensure. And then once they've actually had that entity vetted, it may make it easier for them to raise capital and look for partners, because the partners will also know that the entity has already been vetted, so they can quickly move through the temporary approval application process without having this review be done on the back end before temporary approval is issued. Next slide, please. In terms of definitions, we previously relied on the state's definition of owner, which had been expanded over time. When the city thinks of an owner, we think of a true owner of a business, somebody that has an equity stake or an ownership interest in the business, not a non-duty manager, not a president, not a CEO, not somebody that has the ability to utilize that license for the benefit of the licensee. What we did was we basically carved out just the components that deal with ownership stake or equity interest. So an owner is a person, whether that's a natural person or an entity, with at least a 20% aggregate ownership stake or equity interest in the applicant or licensee. Aggregate means the total ownership interest held individually or through an entity. Person, of course, includes individuals, firms, partnerships, joint ventures, corporations, limited liability companies, trust. Basically, a person, for our purposes, is any taxpayer. Anything with either a federal employment identification number, a social security number, they've got their own unique BTRC number, as well as their Secretary of State number. In terms of primary personnel, that's where some of the things that the state had included in their definition can be found. Primary personnel are always natural people. An owner is also a primary personnel because they have the ability to make material business decisions on behalf of the applicant or licensee. Another natural person who's considered primary personnel are managers, directors, the folks that control the operations of the commercial cannabis business. If the applicant or licensee is owned in whole or in part by an entity, and the entity includes natural persons who manage, direct, or control the operations of the applicant or licensee, those natural persons shall also be disclosed as primary personnel. So if the licensee is owned by another entity and that that company is run by a CEO, and that CEO has the ability to weigh in on the day-to-day operations and the use of the license, that person has to be disclosed as primary personnel. And then, of course, DCR has the ability to determine that additional natural persons have the ability to manage, direct, or control the commercial cannabis business and meet the criteria of primary personnel. And it gives us the flexibility to update our forms on a go-forward basis based on changes either made at the local level or the state level. Next slide, please. This is an overview of our pre-application review and temporary approval application workflows. The workflows themselves have not changed. What we'll be discussing over the next several slides is the timing associated with these workflows. Next slide, please. So for pre-application reviews, the pre-application review will be completed within 30 days of the payment of the pre-application review fee. So once the pre-application review fee is paid, DCR will complete its review of that record. Once submitted, the record data, including the proposed business premises address listed on it, cannot be amended. The pre-application review process is, of course, site-specific. We're looking at a location to determine whether or not it's eligible and compliant, and then we're only looking for a landowner attestation as it relates to eligibility criteria, because the landowner would know better than the applicant in most cases whether or not the location was the site of an enforcement action, padlocking, a utility disconnection, something that would make the proposed business premises ineligible for licensure. So we want the landlord to take ownership over that and disclose that information to the applicants in order to protect them. And of course, to get into the pre-application review process, folks don't have to have a letter of intent signed. They don't have to have a lease. They don't have to have a property deed. So this process is intended to give people ownership and knowledge as to whether or not the location can comply before they make the material business decisions like locking in a lease that it may be difficult to get out of. When an analyst begins their review of the pre-application review record, either the information is there or it's not. So if somebody uploads a placeholder document and while the record is set to waiting for payment and they have the ability to upload additional documentation or put the correct documentation on the record, once the payment is received and we process it and we go into the record to review, you either meet the requirements or you don't. So you're either going to be deemed eligible for further processing or it's going to be marked as ineligible. There is no opportunity to cure as part of the pre-application review process. The only method to cure would be to submit a new pre-application review record. Next slide, please. Of course, once a pre-application review record has been deemed eligible for further processing, the applicant has up to 1 year to submit their temporary approval application. Once that temporary approval application is submitted, DCR will review it within 60 days of the payment. During that review period, DCR will identify any deficiencies with the required documents to get to a status of local compliance underway, which is akin to when a temporary approval application is deemed filed. If there are deficiencies, we will communicate them. Those deficiencies may result in the assessment of additional fees to cover the re-review of additional documentation. In general, folks will be afforded up to 2 opportunities to cure. So if we review our application and we determine that there's a deficiency, we will notify the applicant. The record will be updated to either a status of waiting for payment or additional info needed. Both of those statuses allow the applicant to upload additional documentation to address the deficiency. Processing of the application is suspended until the application has been corrected. It can be corrected earlier than the 30 days provided by code, but at the end of 30 days, the fees need to have been paid and the deficient documents need to be uploaded. If the fees are paid and documents are uploaded, we will conduct a re-review. If upon that re-review, there are still deficiencies, the applicant will get one additional opportunity to cure, subject to the payment of any assessed fees, as well as the submission of corrected documentation. So application records may be deemed abandoned after this first or second review, depending on whether or not the applicant complies with the correction orders to cure. If after our third review, it still doesn't meet the requirements to be deemed filed, it will be deemed abandoned. This process is intended to ensure that temporary approval applications are processed in their entirety within 2 to 6 months. Folks that have all of the documentation in the first time around should be receiving a status of local compliance underway within 60 days. And then of course that opens up the opportunity to request an inspection. And if necessary, go through the equity share review process if it wasn't completed after the pre-application review. Next slide, please. Thank you. As I mentioned, local compliance underway is equivalent to a file temporary approval application. Once the temporary approval application receives a status of local compliance underway, the applicant is able to request an initial inspection. DCR has up to 45 days to schedule an initial inspection once it's been requested by the applicant. In general, it takes about 2 weeks to schedule an inspection. When folks are scheduling an inspection, we ask them to provide us multiple dates and times. And generally, we were able to accommodate at least one of those dates and times. We do our best to work around the applicant's schedule to have minimal impact on their operation. And these inspections are being conducted virtually. So folks do have the opportunity to process them during non-business hours to limit any operational impacts as the applicant may be going through tenant improvements or other things to get their business ready to operate. Another thing is the assigned licensing analyst will now be responsible for doing the initial equity share review. Dr. Brown's team will still be supervising the equity share review process, but her team has limited capacity and they also have other responsibilities, hosting webinars, working with vendors, developing collateral materials to support the social equity program and social equity applicants. So in order to better utilize everybody's time, her supervisor has been cross-training the licensing analyst on how to do the initial reviews. And beginning earlier this month, they started to do the reviews. So we should see a decrease in processing time as it relates to the equity share review. Again, it is still being supervised by Dr. Brown's team. However, the initial review will be conducted by the assigned licensing analyst. And then that will hopefully make the process a little bit easier for applicants because they have one person to talk to both for the temporary approval application record as well as how to comply with any equity share review changes that may be requested. And then of course, within 15 days of either passing the equity share review or passing the initial inspection, whichever occurs last, DCR will update the record to a status of temporarily approved and notify the applicant that temporary approval has been granted. Next slide, please. Another big change is associated with application modifications. By code now, application modifications may be submitted on temporary approval application records during the first 60 days after the temporary approval application is submitted. It is considered submitted when the record is created in the DCR licensing portal. So when you click submit, that is when the 60-day window starts. From there, you of course have 30 days to pay the fee, but that does not change the 60-day window. If you're going to make a change, you need to do it during the initial 60-day window. Otherwise, the record is locked in and we will finish processing it in accordance with the mandated timeframes. If you are unable to move forward with the temporary approval application after the 60-day window, for whatever reason, DCR's only recourse will be to abandon the application and then initiate the refile process. And we'll get into refiling in a little bit later. As part of this new process, folks will have the opportunity to submit entity substitutions, to do 100% ownership changes, to do most of the modifications that licensees have the ability to submit. The one exception is you cannot amend the business premises location. That is tied to the pre-op process. That is tied to what activities may be pursued through the temporary licensure process. If you lose site control, you're unable to execute a lease, you will have to start the process over. And then, of course, once the temporary approval application has been submitted for more than 60 days, DCR will not accept any modification request until a license is issued. And then the last piece is application processing, of course, is suspended during the modification process. We can't process a record towards temporary approval until all of the documents are locked in and we have the ability to verify that the documents are consistent across one another, as well as across the record that's before the department. Next slide, please. So the types of modification requests that can be submitted during the 60-day window include legal name changes, fictitious name changes, entity substitutions, removing commercial cannabis activities if you no longer want to pursue them, updating your business premises diagram, modifying the ownership structure, adding or removing owners. And of course, if you don't want to move forward anymore, you can withdraw your application. There are two types of modification requests that do result in the creation of a new temporary approval application record. And those are entity substitutions, because the applicant is changing. It's a new taxpayer, it's a new legal entity. So they get a clean record for that, as well as when 100% of the owners are changed. For the 100% ownership changes, the person who created the pre-application review, who was at that point in time either a law firm, a consultant, an authorized agent, or one of the primary owners, has access to that record, which cannot be broken. So in order to ensure that only people associated with this ownership group and none of the legacy owners have access to the record, we do have to create a new temporary approval record. And that is why when those two record types get created, we charge a new temporary approval application fee, because everything has to be recreated and resubmitted to the department to reflect those major changes. Next slide, please. Now I'm ready to hop into the refiling workflow. And this is a new workflow that was recently uploaded to the department's website. And as I mentioned, this is a process that just started last week. On Friday, April 15th, the ordinance that basically effectuated the accountability, the timelines, the ability to refile, the changes to the definitions all went into effect. And on Monday, April 18th, refiling became a thing in the portal. And DCR is re-reviewing all of the records that do not have a status of local compliance underway. We are in the process of determining whether or not the record should be abandoned, or whether or not the applicant should have an opportunity to cure deficiencies if they met one of the other milestones or timelines that were previously provided. That review is conducted at the analyst level. And if it is determined that a record is abandoned and the record itself is eligible to be refiled, the parent record, which is the original temporary approval record, will have a status of abandoned -refile. And what that status allows an applicant to do is to start a new pre-application review process. A refiled application must be started within 1 year of the date the applicant is notified that the record was deemed abandoned. Once the record has been refiled, a new pre-application review record is completed, and then it follows the normal process. The prospective applicant has 30 days to pay the pre-application review fee. If they don't pay it, the pre-application review record gets deemed abandoned, and provided that they still have time left since the record got abandoned, they're still in that 1 year time frame, the record that got abandoned will be updated back to abandoned refile so that they could submit a new pre-application review record. For refiled records, you can only have one pre-application review record or temporary approval application record pending at any given time. So you can't propose multiple business premises locations and then wait to see whether or not they're eligible and then pick one. You have to submit it one at a time. And ultimately, if it's deemed ineligible, you can then go back and choose to refile for a different location, or if you're unable to move forward at that proposed location, once you get a status of eligible for processing, you'll be able to notify the department so that we can abandon the pre-application review record and then reset your temporary approval application record, provided it's still within that 1-year time period. Of course, if you do receive a status of eligible for processing, you have up to 1 year to then submit your temporary approval application to the department. So refiling is just a mechanism for folks that are unable to move forward with temporary approval at this time to have an opportunity to pursue that, to pursue temporary approval at a later date, provided that they start that refiling process within 1 year. And then the pre-application review process and the temporary approval application process are exactly the same for a refiled record. Once a record has been refiled, it cannot be refiled again. So folks don't have the opportunity to file, get abandoned, refile, get abandoned, refile, get abandoned. You get one opportunity to refile per temporary approval application record. That is it. Next slide, please. So I spent a lot of time on the workflow, kind of walking folks through the process. And now I'll kind of deep dive into some of the technical changes about the refiling process. First, the mayor and city council made refiling retroactive to January 1st, 2022. So a temporary approval application record that was deemed abandoned after January 1st of this year may be eligible to refile. And I'm in the process of re-reviewing those abandoned records. And if we determine that it is eligible for refiling, then of course we will go ahead and get the status updated to abandoned-refile, which will initiate that process. The second thing is refiling must be initiated through the DCR licensing portal within 1 calendar year of the date. DCR notifies the applicant by electronic mail that the temporary approval application was deemed abandoned. And to refile, the applicant submits a new pre-application review record. If the record is ineligible for further processing, the applicant may submit new records, provided it's still within that 1-year time frame, subject to the payment of applicable fees. Next slide, please. This is critical for folks, and especially our phase 2 applicants and our phase 3 retail round 1 applicants, because there are so many who have not had their temporary approval application record deemed filed because they have not submitted all of the necessary documents, information, and forms to receive a status of local compliance underway. A refiled temporary approval application is not subject to a finding of undue concentration. So if you are a phase 3 round 1 applicant that does not have site control, so you don't have a pending location before the department, your record cannot move forward. There is no path forward for that record at this point. So either you notify us that you don't have a path forward, you lost site control, you execute the business premises surrender form, or tell us that for reason A, reason B, you are not able to move forward and you would like your application to be abandoned. That would be one mechanism. The other mechanism, of course, is to not comply with the processing timelines that have been recently adopted, which will result in a record being deemed abandoned. There are hundreds of folks that are unable to move forward with temporary approval. Those records may be deemed abandoned, depending on what the applicant decides to do. If they are abandoned, they are afforded 1 year to start the pre-application review process. A refiled record has to be in the same community plan area as it was originally filed, but that refiled record will not be subject to a finding of undue concentration, which means that if you were a phase 3 retail round 1 applicant and you're deemed abandoned in June and DCR starts the phase 3 retail round 2 lottery, and through that lottery, phase 3 retail round 2 applicants reach, submit sufficient applications and licenses are issued to reach undue concentration in your community plan area, you will still have the opportunity to go through the pre-app review. You will still have an opportunity to submit a complete temporary approval application without it having to go through the PCN process. And that's just important for applicants and licensees to understand, because I know undue concentration is a big concern for folks who do have pending records within our queue. Next slide, please. Refiled records cannot seek authorization to conduct any commercial cannabis activity that is not listed on the temporary approval application or outside of the community plan area listed on the original temporary approval application. For our purposes, whatever is on the temporary approval application record, when it is deemed abandoned, is considered to be the original temporary approval application record. So if you were a phase 2 applicant who started this process back in 2018, and you've gone through several modifications of your first temporary approval application, it was the same record. It was just getting modified. So if that record gets deemed abandoned, that is your original record. As I mentioned, refiled records that were not subject to a finding of public convenience or necessity, refiled records are not subject to a finding of undue concentration, so they don't have to go through the PCN process if the community plan area reaches undue concentration. However, if a record was created through the PCN process, because the PCN finding is site specific, it can only be refiled at the same proposed business premises address. If a refiled temporary approval application is later deemed abandoned for any reason, it may not be refiled. Next slide, please. I know some of our public members asked questions about the environmental process earlier today. We have formally started the environmental analysis process. We are finalizing the project description form, which will be posted to the website in the next week or two. That project description form is materially similar to the form the Department of Cannabis Control, which is the corresponding state agency, uses. So once you've gone through our process, hopefully it's in a form and manner that is helpful to the state to help facilitate moving you through the state's annual application process. We'll kind of get into the nuances, but when folks go through pre-app review and then they submit their temporary approval application process, whether they know it or they don't, they've submitted their draft project description to DCR. And that project description is tied to where they want to conduct business, what activities they want to conduct, doing all of the location and eligibility related review, separate and apart from their ability to lock in their final project description, which does have to go through the full-blown environmental review. So folks are in our process. Folks that have a filed temporary approval application, which means that you have at least a status of local compliance underway, will receive a environmental letter from the department before the end of the month. And you may be skeptical, but I have 2 days to get those letters out. I got tomorrow and I got Saturday. And we have created the statuses within every single record that the state is looking for. They want to know whether or not the applicant has local compliance. They want to know whether or not a project description is under review, and they want to know whether or not CEQA compliance is underway. So if you have a status of local compliance underway, or you have a temporary approval license, you will get an environmental review letter. And those letters will continue to be issued on a rolling basis to applicants who meet the threshold for getting a record status of local compliance underway. Those letters are important because it's the local piece of evidence that existing licensees will need to either renew their provisional license after July 1st of this year, or to apply for a provisional license if they're applying for cultivation or they're a social equity applicant with the state. So those are going to be critical letters. They are needed prior to July, and folks will have a full 2 months with their letter to make sure that they can get it to the state before you have to renew your state license under the new state requirements. When temporary approval is granted and you have a license, that is when a business will be allowed to submit their final project description. The submission of the final project description, which will be on that DCR form, which will be posted shortly, will basically put you into the environmental analysis process. DCR has partnered with the Department of City Planning. City Planning has a very robust environmental consultant bench. They have been kind enough to allow DCR to utilize their bench, and we will be doing vendor conferences with their bench next month. During those conferences, we're going to explain what we're looking for and how these project descriptions need to be reviewed. The expectation is we will be working with vendors. We will be identifying geographic areas for these project descriptions to be analyzed and identifying which vendors are going to do that in parallel with our licensees completing their final project description forms and getting them submitted to the department. In either late June or early July, our hope is that we will have a sufficient number of these project descriptions to bid out so that our consultants can then begin working on them. And then of course, they will complete the analysis on a rolling basis, give it back to DCR, and then we will have the opportunity to review it and determine whether or not we're going to accept it as a department, or we believe that there are further revisions necessary. During this process, if additional information is needed, the applicant or well, in this case, the licensee will be corresponding directly with the firm that is assigned to work on their project description. That will help facilitate the transfer of information to the analyst doing the review to ensure that they have everything necessary so that DCR gets back a final product in the most efficient manner possible. We fought long and hard with the state over this issue. We wanted the state to be the lead agency, and we wanted to be able to review their annual license. We wanted to be able to review their environmental analysis. They took steps last year to flip the script on us and have us be the lead agency. As such, moving our folks through this environmental review process, which is a prerequisite to submit an annual license application, is of the utmost importance. And we'll talk about why it's of more importance later on as we get into some of our timelines. Once DCR locks in the final project and you're eligible to start the annual application process, that will be your opportunity to provide whatever missing documentation exists on your record so that you can actually get a notice of complete application, and then we can begin the final annual application processes. And we'll hop into it a little bit later in the presentation. Next slide, please. Next slide. So as I mentioned, we're authorized to use City Planning's internal environmental consultant bench. Those will be the consultants that are doing the environmental analysis on behalf of DCR. We will begin collecting final project descriptions. The form hasn't posted, so we're going to begin collecting it early next month. Project descriptions will be bundled for environmental review based on the geographic area. That should help facilitate the review and move as many licensees through the process as possible, because our licensing structure is based on community plan areas. Community plan areas tend to have similar environmental characteristics. It only makes sense to batch people based on those community plan areas so that The analysis based on those characteristics are being conducted at the same time. Authorized consultants will have 4 to 6 weeks to respond to the RFP once we've put it out to bid. And our intent is that we will quickly review those bids and then start to issue notices to proceed so that they can start to conduct the environmental analysis. And then, of course, the consultants will analyze the final project descriptions and assist DCR with making findings. Next slide, please. The next piece that the director mentioned, we will be opening the social equity individual applicant eligibility verification process next month. An announcement will be coming out in early May to tell you exactly what date in late May we will open that process. The process will be open for 60 days. You must submit your eligibility verification request during the submission window, or you will not be able to request verification for the remainder of calendar year 2022. This process will not open up again this year. So if you would like to get verified, whether you want to participate in phase 3 retail round 2, you want to pursue a cultivation license, you want to pursue a non-storefront delivery license, you're a phase 2 applicant that didn't get verified the first time around, this is going to be your one opportunity this year to do that. There's a 60-day filing window. You got to get your eligibility verification request submitted in that window, or it will not be considered and you will miss out on the opportunities to submit an application as a social equity applicant. Once the 60-day window closes, DCR has at least 90 calendar days to process eligibility verification request, which shall not run concurrently with the 60-day period. The code prohibits us from starting to do the review and cutting into the time prior to the close of the window. Once the window has closed, we have at least 90 days to complete the processing. And I say that because it's important. If we are overwhelmed with the number of submissions and it takes longer than 90 calendar days to process, we will complete processing before we even have any discussion about when the phase 3 retail round 2 lottery will happen. The verification period is a prerequisite for the lottery. The lottery cannot happen without it. We can't tell you when the lottery will happen until we complete the verification window and we process all of the verification requests submitted. Our goal, based on opening this in May, is to get everything processed so that we could administer the lottery before the end of the calendar year. Our ability to meet that timeline is going to be based on our ability, how many things get submitted, how many analysts we can put onto verification. We will be getting 7 additional licensing personnel, which will be onboarded prior to the close of the 60-day filing window. So we should have sufficient capacity to administer or process over 2,000 of these requests like we did back in 2019. But we don't know if it's going to be 2,000, 3,000, 4,000, 5,000, 10,000. Until the window opens and closes, we have no idea what that workload is going to look like. We're just making assumptions that we will get thousands. Of course, once we've administered the verification process, we will be allowed to start the phase 3 retail round 2 lottery. That will be a registration process. Registrations for the lottery will be open for a period of 30 days from eligible social equity individual applicants. In parallel with the registration process, as well as the 90-day processing period, DCR will administer technical assistance to let folks know what to expect and how to register for the lottery. That technical assistance will begin before the registration period opens. We are required by code to start technical assistance at least 45 days before we administer the P3 round 2 lottery. Eligible registrants will be entered into the phase 3 retail round 2 lottery. Eligible registrants are social equity individual applicants. You are not required to identify an entity. You're not required to have a location. You are not required to have a business entity. You're not required to have anything necessary to complete the temporary approval process or the pre-application review process to participate in the lottery. The lottery will be literally registering your intent, DCR verifying that you are eligible to participate in the lottery, and then conducting the lottery to identify the 125 plus people who will have the opportunity to submit a phase 3 retail round 2 application. DCR is required to post notice at least 15 calendar days prior to the lottery. And we can't tell you when the lottery is going to be until we do everything in the workflow process before the lottery. And based on workload, of course, those dates could shift. We don't want to make false promises. We want to make sure that people understand a realistic process. Next slide, please. What I did here is I built some tables based on the 2 different processes. So part 1, of course, is the social equity individual applicant eligibility verification. We're going to announce the social equity eligibility verification window early next month. We'll open it at the end of next month. We are not required by code to provide notice. DCR is making the announcement early in May so that one of our vendors, North Star Alliance, will be doing webinars and assisting prospective individuals who want to get verified with what the process is going to look like, as well as how to complete the requirements of the forms. I will be participating in the first webinar they do, and then they will take the lead from there to continue to do webinars up until we open the verification filing window. Once the window opens, it will be open for 60 days. That is set by code. DCR does not have the discretion to extend it beyond 60 days. DCR does not have the discretion to make it less than 60 days. The window will be open for 60 days. Once the filing period closes, of course, we have at least 90 days to process the verification request. It may take longer, but in total, just to get part 1 done, it's going to take 6 months. We can't lawfully do a lottery until part 1 is completed. So the lottery can happen no sooner than 6 months from now. But we do have it timed to hopefully be able to be administered prior to the end of the calendar year. Next slide, please. This one is now a breakdown of what a round 2 lottery would look like. So in order to be eligible to participate in a lottery, you must get verified under the new criteria. So somebody who was verified in 2019 is not eligible to participate in the lottery unless they get verified during this process. That is important. If you've been verified and you want to participate in the lottery, you will have to get re-verified. In addition to being re-verified, the social equity individual applicant must have a prior California cannabis arrest or conviction. That was a policy change made by the City Council last year. If you do not have a qualifying arrest or conviction, you will not be eligible to participate in the lottery. If you do have a qualifying arrest or a conviction, and you have been verified, that means that either you met the requirements to be considered low income, or you had residency in a disproportionately impacted area, or both. If you have all 3, that is great, but you must have the California cannabis arrest or conviction and one of the other 2. DCR will be providing technical assistance to prospective and verified social equity individual applicants. That is critical because we can start the technical assistance piece for the registration process before we have completed the verification window. So folks that have submitted to be verified during that 60-day window, regardless of whether or not you've been verified or we're still processing your request, you will be eligible to participate in the technical assistance. because we have the ability to overlap the technical assistance requirement with the processing of the social equity individual application verification request, we will be doing that to streamline the time and to allow us to administer the lottery sooner. Once we've provided the technical assistance, the lottery registration period has to be open for at least 30 days. We have to post notice of when the lottery will occur. We have to provide at least 15 days notice. We may be able to run that in parallel with the registration period. I will report back at a later date on whether or not we've been advised whether we can do that or we've been advised we can't do it. In our ideal world, we will run as many processes in parallel with one another to ensure that we can get to the lottery as soon as possible. The lottery itself will only take a day. We will identify at least 125 social equity individual applicants that will be eligible to submit applications as part of phase 3 retail round 2. Folks have up to 1 year to initiate the pre-application review process. And then of course, if your pre-application review record is deemed eligible for further processing, you have 1 year to submit your temporary approval application. So the process has been designed to allow folks to participate in the lottery without any skin in the game. And if they are selected through the lottery, they have a year to identify a compliant location in any of the community plan areas that have not reached undue concentration. And if they select a proposed business premises address that is eligible for further processing, and they will have up to a year from that date to then submit their temporary approval application. Next slide, please. This is all important because of the state deadlines. So local equity applicants, which locally we refer to as social equity applicants, have to submit their application for a state provisional license by March 31st of 2023. So to try to give phase 3 round 2 applicants an opportunity to meet this deadline, it is our goal to administer the lottery before the end of the calendar year so that folks have the ability to pivot quickly into getting through pre-app review and then starting the temporary approval process and getting to a status of local compliance underway. If you are selected through the lottery, there's nothing that precludes you from submitting an application to the state by this deadline, regardless of where your local application is. However, in order for the state to process your provisional application, they will reach out to DCR and you must have a status of local compliance underway or you will not get a state provisional license. The Department of Cannabis Control has until June 30th to issue new provisional licenses to social equity applicants. Beginning on July 1st of 2023, renewals will be subject to additional requirements. So the state is going to be attempting to march licensees toward the annual licensure process. And ultimately, beginning on January 1st of 2025, the Department of Cannabis Control will no longer allow licensees to renew a provisional license. After that date, you either have an annual state license and you can lawfully operate, or you don't, and you have to stop operating until you get your annual state license. That is why for our existing licensees, it is going to be important for you to participate in the environmental review. And then, once you've completed the environmental review, meet the requirements to have your application deemed complete so that you can begin the formal annual application process. Because if we are not able to issue our local annual license, which includes the adoption of the environmental findings for your specific project, you may not be able to meet the state's annual application requirements that will require that environmental document, and you may have to stop operating. So we are taking these deadlines seriously. We have 2.5 years to move almost 700 businesses through this process. the resources we were granted earlier this year, in conjunction with the $22 million from the state, will help facilitate moving folks that do participate and get information in through both our local process and the state's process. And then, of course, by January 1st, 2026, there won't be any more state provisional licenses out there. Next slide, please. So this will kind of be the tail end of my presentation. I'm just going to briefly touch upon the annual license application. One of the critiques we received from multiple licensees was, why is DCR asking us to resubmit all of the temporary approval documents in the current form and manner? Why do we have to submit all of this documentation? The rhyme and reason behind that was all of that documentation is going to be necessary for us to deem your application complete and move you through our annual license process. So by having all of our existing licensees demonstrate that they meet the current requirements for temporary approval, that ensures that those are documents that we're not going to have to recollect as part of this annual license application. Every phase had different requirements. People entered our process at different times. They had to meet different requirements to get temporary approval. The annual license application process is consistent across phases. You have to do everything necessary or you don't have a complete application. So selfishly, wanting to move people into our annual license application process this year, we had everybody resubmit the TA documents so that as long as they're in the correct form and manner and they're complete, you are one step closer to having a complete annual license application. For phase 2 applicants, you'll have to go through equity share review. For tier 3 phase 2 applicants, you'll have to execute your social equity agreement with the city. For, applicants that haven't submitted a labor peace agreement or their labor peace agreement has changed, either they executed a labor peace agreement or they're in the process of doing a labor peace agreement, we want to know that because it's part of our annual application process. Any ownership and primary personnel updates, those need to be made before we deem that record complete, because once we deem it complete, we've got 90 days to make decisions, either to make a recommendation to this commission to recommend the issuance of an annual license, or I get to make a recommendation to the director for the issuance of an annual license for non-storefront delivery records and for non-retail activities that are less than 30,000 square feet. As part of the annual application process, everybody is going to have to go through a final inspection. Rocky's new unit that was recently adopted, that will for the first time give us resources dedicated to inspections, ensuring that folks continue to be compliant with our rules and regs and local law. And if they're not, allow us to take enforcement actions against the licensees and issue notices to correct. Those positions will be coming this summer, and those positions will be facilitating these final inspections. Retail storefronts will have to go through a community meeting, which will be facilitated by the Department of Cannabis Regulation. We have already talked to the personnel department to ramp up and hire as needed administrative clerks to staff these meetings and take notes. We will have sufficient licensing folks to have a supervisor and analyst at these community meetings, as well as administrative support to take notes based on the public comment. That public comment will be summarized and it will be presented to the final decision maker, whether it's the director or this commission. Of course, folks will have an opportunity to submit written public comment to the decision maker. Depending on the type of license, DCR may have to post notice and provide notice to the public. And then of course, retail storefront licenses and non-retail licenses with square footage over 30,000 square feet will have to go through this commission, and a commission hearing will be necessary. I will tell you, in my capacity as the head of the licensing section, if we are going to deny a record, it will be done prior to making a recommendation. If there is a reason to deny, If an applicant doesn't meet the requirements, we will take care of that. If we are making a recommendation, whether it's to the director or to this commission, our recommendation is to approve that license. So things that are coming to either the director or to this body are going to be requests to approve from the department because the business has demonstrated that it meets the requirements to receive their annual license. Next slide, please. Before I hand it back over to our commission president, I did want to mention that we do have a limited amount of grant funding for fee waivers. We have sufficient funding to provide fee waivers for the social equity individual applicant eligibility verification process. Those waivers will be provided on a first come, first served basis. Once those grant monies are exhausted, we have no other monies to provide fee waivers for verification request. And folks will have to pay the $597 verification request fee. So if you are interested in getting verified, I encourage you to participate in the webinars leading up to the launch. I encourage you to put together your checklist and collect your documents. So when that window opens, you participate early and get things submitted so that you can be the beneficiary of those fee deferrals. The second set of fee deferrals that we have available to us come courtesy of the $22 million CLJAG grant. Those monies are to support our licensees across all phases. Approximately half of the monies will be supporting moving folks through the annual application license process. So for folks who have their annual license application deemed complete, which then is a requisite to get your invoice, we will be providing fee waivers on a first come, first served basis. And then of course, we have monies to complete the environmental review, which will be done through the fee waivers. So for folks that participate early in the environmental review process, to the extent that your project description only requires a categorical exemption or possibly a statutory exemption if one exists for your business, the corresponding environmental fee will be waived courtesy of those CLJAG grants. If your project description doesn't result in an exemption, you will be responsible for paying whatever the additional environmental fees are. And the fee amounts for the initial study and other things can be found on the fee chart, which is part of 10419. And with that, I would like to turn the presentation back over to Commission President On. Thank you.
Thank you, Mr. Clean. That was very informative. A lot of changes, important changes, in particular with regard to CEQA. At this time, I'd like to open up the floor to our commissioners for questions, comments, and deliberations. Commissioner Villa?
Yes, that was quite an impressive presentation, and I really appreciate all the work that Mr. Colleen and DCR put into making this presentation to us today. I especially want to commend Dr. Brown and everyone in the department who's worked so hard to get that social equity percentage up to 36%. I mean, that's really impressive, and to have a goal of going to 50% is amazing. To have gotten the $3 million assigned for social equity again in this budget period, it's just amazing and commendable, and it's been a long time coming. And I know that obviously you all worked, everyone, Dr. Brown and everyone in the department has worked very hard for that, and it's just really gratifying to see that it's finally coming to fruition. And I just thank everyone for their efforts. It's really impressive. Thank you.
Thank you. Anybody else? Mr. Clean, I did have a question. So the the document that we're planning to prepare, the environment, and I forget what, remind me what that title was again, environmental reviews underway.
Yeah, it's effectively it's their environmental project description letter,
Mhm.
which confirms that their project description is under review and their CEQA review is underway.
Secret reviews
And
underway. Okay.
yeah,
And that will allow for the renewals of the provisionals.
that is correct.
Okay.
So
I don't know if you have this or if you might know offhand, but section 15010, which is which has a heading, this is in the state regs, compliance with CEQA. Are you familiar with this provision?
I am.
So, there's part one and part two. So there's two documents that would satisfy the CEQA requirement with regard to this specific provision. Question is, there's document for B1 and B2. Would this satisfy B2, or is this an entirely different application?
Give me 1 minute to bring up the exact text so I can look at the specific language.
Yeah, I'm not sure if
Um,
this might be more appropriate for, or this applies maybe for the annual. I'm not sure. I'm just trying to figure out.
So there's two pieces for the compliance. For the
Hmm.
renewal of the provisionals,
Hmm.
a letter from the local jurisdiction, which indicates that the project description is basically under review and the CEQA review is underway, are sufficient. So we created a new set of data fields and we have been sharing those data fields with the state agency
Hmm.
so that our temporary approval applicants can move through their process a little bit sooner because there were still hangups at the state level about this local compliance and whether or not CEQA had started. So we've resolved that issue. And the letter that we've prepared includes those data fields and those statuses. And everybody with a status of local compliance underway or a temporary license will get this letter, which to date satisfies the state's requirement for this calendar year and to renew the provisional license beginning in July. For the annual license process, that gets a little bit more tricky. Um, we represent over 25% of all licensed businesses within the state. And if our pipeline holds through, we could actually hit 40 or 50% of statewide licenses before everybody else has an opportunity to catch up to us. We have gone back and forth with the state over CEQA, and we have both argued why the other person should be the lead agency. Unfortunately, I lost that battle. To ensure that folks meet the requirements for the state's annual process, my recommendation for our licensees, and I think the best option for them would be to get through our annual process. As part of our annual licensing process, that decision maker will have the opportunity to adopt our local environmental findings. That does trigger an appeal process. The state has informed me that if it clears that appeals process, it will expedite the processing of the state annual application. So for provisionals, I know because of my conversations with the directors that our letter is sufficient. For an annual license process, get through our annual process, have your environmental documents approved, and survive any challenges, and you should be good as gold when you get to the state's annual process.
So to clarify, the CEQA underway letter is for the provisional.
Yes, it
And
is.
then for the annual, at the state level at least, we'll have to actually go through the process and survive the appeal period. And then at that point, the local applicants will have cleared the CEQA requirement.
Correct.
Okay.
The state for their annual process wants to see adopted findings, and they don't consider the findings adopted until they've been adopted by the decision maker and they've survived any appeals or challenges. And as you know, that those appeal processes can be rather lengthy, and to start sooner would ensure that you get through our process, get to the final decision maker, and then have at least a year and a half to overcome any environmental challenges.
Okay, thank you for the clarification. I see Vice President Mason has her hand up.
Thank you. Thank you, Mr. Killeen, for your presentation. I have a question. Of the 53 Phase 3 Round 1 social equity applicants who've received temporary approval, do we have a number on how many are actually open for business?
I do not have that for you.
Okay. Is it possible to report on that at our next meeting?
I will talk to Rocky, and we'll see whether or not we can send compliance folks out into the field to do a field verification. And then we'll also be we can do a survey as well to email out to folks to let them self-certify whether or not they begin to operate.
Okay, understood. Thank you.
Yeah, under our new process, because we streamlined it, we no longer require them to demonstrate that they've met every other agency's requirements. We decoupled it.
Okay.
So, you do have to have the state license to lawfully operate. And, at this point, we don't know if they've secured their state license as well. But we can report back at the next commission meeting.
Appreciate that. Thank you.
Great. Anything else?
I just
Okay. Yes,
want
go
to
ahead.
say thank you to my team. You're few but mighty, and things will be better when reinforcements arrive in 2 months. So thank you guys for all your hard work.
Great. And Mr. Colino, we appreciate your efforts as well, and extend it to the team. Overall, I think we're definitely on the right track. I'm pleased to see a lot of the changes in the process. It looks much more streamlined, and we're very hopeful and confident that we'll start to see the fruit of our labor to date. So thank you again. Let's move on to item number 5, social equity program updates. Dr. Brown, are you available?
Yes, I am.
Hey, Dr. Brown.
Hi, everybody. Good afternoon, commissioners. I hope that you're all well and thriving. Today, I'll be providing an update on the social equity program and what we have accomplished since I last presented to this body. Next, please. In light of this, I would like to remind everyone of the mission of the social equity program, which commits us to this work every day. The mission of the social equity program is to promote equitable ownership and employment opportunities in the cannabis industry in order to decrease disparities in life outcomes for marginalized communities and to address the disproportionate impacts of the war on drugs in those communities. Next, please. Next, please. Our business licensing and compliance program offers program benefits and resources that includes application processing, business licensing and compliance assistance programming, our seed grant program, and pro bono legal services. Next, please. And now I'll provide updates on our business licensing and compliance program. The April Live webinar events preview. This is the list of the webinars that we have hosted in April. This month focused on an advanced dive into topics covered in our fall webinar series. It also featured an expert panel on identifying funds and raising capital. Tonight is our last webinar on the topic of advanced transportation and delivery in the April webinar series. Next, please. This is our April virtual advising sessions. This is the times and list. This month's virtual advising sessions, they covered the business of virtual vertical businesses within the Los Angeles cannabis market, which included retail, delivery, distribution, and manufacturing. These were private one-on-one coaching sessions that were very successful. Next, please. As a part of our business licensing and compliance program, workforce development is a component of that initiative. The GROW 2022 Career Fair was held on March 18th virtually and March 19th at the LA Trade Tech College. It was a wonderful success. One of our retailers hired 10 job seekers on the spot. A number of other job seekers were able to continue in the interview process with other employers. Additionally, the fair offered the opportunity for retailers, manufacturers, delivery operators, and distributors to connect. One of our social equity manufacturers was able to expand into a number of new retail locations as a result of the networking career fair. Next slide, please. We'd like to share a short video of the career fair highlights that was filmed by Channel 35.
We have over 26 cannabis employers and job seekers, and we're offering this venue for them to do live interviews. We see this huge burgeoning market with all these jobs available for prospective job seekers.
So we're hiring new teams for our stores. So we're here to actually offer positions to people in Los Angeles.
We're going to be hiring between 15 and 25 new employees. We're looking for employees as bud tenders and eventually hope to move them up to management.
Today I'm out actually looking to fill about 8 different positions under our licensing for Greenhaven, LA. We're licensed to cultivate, so I'm looking for metric specialists, procurement specialists, logistics specialists. I'm also looking for those that have experience in cultivation.
Las oportunidades que ya hay dentro de la industria, porque la industria ha crecido y tiene diferentes componentes de lo que es crecer la planta, preparar la planta y convertirla ya en un producto.
I think a career fair is a great idea. I mean, like I just got out of college pretty recently, so I've been going to different career fairs and just trying to figure out what I want because I don't really know what I want to do, so I'm trying to figure it out.
It's definitely helping because it's giving resources and access to people that wouldn't know what kind of jobs are available. So for example, when people come talk to me and I say, I'm looking for retail employees, you don't have to have cannabis experience.
People don't realize there's so many jobs in the cannabis space. We need people who have marketing and branding expertise, inventory control, accountants, attorneys. There's just so many transferable skills that people can use in the licensed cannabis market.
Even if they don't have the experience, I'm currently looking for someone that has enthusiasm, confidence, and they're coachable and trainable.
Para dar trabajo a la gente, para educar a la gente y para traer a la gente a entender un poquito qué es lo que cannabis puede hacer para la comunidad, para la economía y para la salud y bienestar.
Thank you. That was the first live event that we've done as a department in 2 years, so it was exciting. This virtual job networking, and we did that today. We hosted this networking event, which allowed our job seekers and interested employers from the job fair to continue engaging and scheduling one-on-one interviews. So that happened today from 10 to 2. Next slide, please. As a part of our business licensing and compliance initiative, we have launched a capital caseworkers pilot. I'm excited to announce that this innovative pilot has launched. The program uses a coaching model to assist applicants with overcoming common hurdles to successful entrepreneurship. Our current applicants meet weekly with our capital caseworkers to discuss their unique challenges on how to solve these issues. The coaches point them to resources supplied by DCR, including our live webinars and our virtual advising sessions, our pro bono legal services, and self-guided curriculum in the LMS. Coaches also point applicants to other services outside of the department, which help alleviate these pain points. Currently, the coaches are assisting applicants with finding compliant property, navigating complicated investor relationships, identifying new sources of capital, and other operational challenges. I really look forward to submitting a full report on the success of this pilot in June and to a discussion about our plans for expanding the program to cover additional social equity applicants. Next, please. Our pro bono legal services assistance. We've expanded eligibility for the pro bono legal program to include delivery applicants. were deemed eligible for further processing. Communications went out to these applicants by email and text messaging. Now, if they did not, or if you do not receive this communication, please, but believe that you are eligible, please contact dcr.sep@lacity.org and we can assist you. We really encourage people to take advantage of this free legal service. Next slide, please. This screenshot is of a page that you can sign up for this service. Please complete the online survey and upload the authorization agreement to complete the process. It's a 2-page document that will sign you up. It's a really easy process to have access to these legal services. Next, please. And now I would like to introduce Paula Groves. She's the CEO of Elevate Impact LA and our Seed Grant Administrator. She has conducted a survey of our Seed Grant recipients on their greatest barriers to successfully entering the cannabis marketplace here in LA. I'll turn it over now as she presents her findings. Groves?
Thank you so much, Dr. Brown. As Dr. Brown mentioned, my name is Paula Groves. I am the CEO of Elevate Impact. We were contracted by the City of Los Angeles to administer the Social Equity Entrepreneur Development Grant Program, or SEED Grant Program. Next slide, please. In April of 2021, the City of Los Angeles established the SEED Grant Program in order to distribute funding from the Cannabis Equity Grant Local Jurisdictions, or CEG Grant Program, to provide financial assistance to verified social individual applicants. In late 2021, the City of Los Angeles distributed $6 million to qualified seed businesses. Working with the Department of Cannabis Regulation, a survey was conducted in early 2022 of the LA Seed Grant recipients. And this report highlights the results of this survey. The purpose of the survey was to assist DCR with the development of programs and services for the SEED program. Next slide, please. At the time of this report, 84 out of 206 grant recipients had responded to the survey, equating to a 40% overall response rate. Such a high response rate indicates that grant recipients are highly engaged. I want to extend my appreciation and gratitude to the seed entrepreneurs, as well as to DCR, for their commitment to the SEED program and taking the time to provide this valuable feedback to continuously improve the SEED program. Next slide, please. 85.8, or nearly 90% of survey respondents were either a storefront or a mobile dispensary, suggesting that dispensaries are a very important component of the SEED program. Next slide, please. Now we will move to the results portion of the presentation. Next slide, please. The survey captured both quantitative data and qualitative information using multiple choice questions, as well as allowing SEED grant recipients to respond in their own words. The survey revealed that seed businesses are quite young, need capital, and remain vulnerable. This report also summarizes obstacles faced by seed businesses and makes recommendations about how these obstacles can be addressed. Next slide, please. When reviewing the consolidated responses, we find that the top 5 items that are most top of mind for the SEED grant recipients include, in rank order, 1, navigating the DCR process, 2, raising capital, 3, taxes, 4, finding a location, and number 5 was competition from the illegal market. Next slide, please. In terms of these youthful seed businesses, we learned that 30% are operating and generating revenue, 76% have less than 5 employees, 52% do not have state provisional licenses, and 32% offer health insurance. Next slide, please. When asked a series of questions regarding problems faced and what has helped their businesses most, the need for capital was the number 1 answer. Other statistics include 1, 66% of respondents want both grants and loans. 2, 60% have never received outside capital. And 3, 42% spent grant funds on rent. Next slide, please. Now, in terms of vulnerability, 69% do not have a business banking account, 27% have had an account closed by a bank, and 43% say that competition from the unregulated market has most hurt their business. This was the #1 answer when asked the question, what has hurt your business the most? Next slide, please. Now we will move to the recommendations section of this report. Next slide, please. So the #1 question we're probably all asking ourselves is, what can the city of Los Angeles do to help? Provide capital was the #1 mention, followed up by help with the DCR process, and then finally lower taxes. Next slide, please. Ways to address this feedback include: 1, continue the grant program; 2, consider an interest-free loan program for later stage businesses; 3, look for ways to decrease friction in the DCR process; 4, become vertically integrated as a micro business to compete more effectively. This is an opportunity opened only to social equity businesses.
Next slide, please.
Thank you, Dr. Brown.
This is the wrong slide. Thank you.
Thank you. Provide examples of how to use the pro bono legal services. And then finally, continue grant distribution via ACH transfer. Next slide, please. I would like to conclude this presentation by sharing some quotes from the SEED grant recipients in their own words. Getting to be one of the first social equity applicants has helped, as it has allowed me to gain early market share. Next quote, funding for build out was most important. Everything else is lining up. Next quote, my biggest accomplishment is actually being given the opportunity to participate in the Los Angeles cannabis market, handling multiple different applications processes with zero business background on business development, and I have successfully acquired multiple license types. My final slide with quote. The grant programs and pro bono attorneys are great tools to help get started, along with the information webinars and support from the DCR and LAC grant. Next quote. The social equity program has helped me attract investors who are willing to back me, but only under certain conditions. Final quote. I'd like to thank DCR as well as the SEED group who facilitated this grant process. I have put all my eggs in this basket, and I hope it turns out fruitful. Next slide, please. Thank you. Now I, together with Dr. Brown, will take questions.
Thank you, Dr. Brown. Thank you, Paula. Commissioners, I want to open it up, questions and comments. We got Commissioner Naro, then we got Vice President Mason.
Thank you, Dr. Brown, for this excellent presentation. I do have a question about the career fair. I noticed at UCLA there's a cannabis student organization that's growing, and I think that might be the case in other campuses. But maybe at some point I would like to follow up with you to figure out how to connect to those different student groups, because I think that it would be great if they can have access to some of the resources you outlined, especially the job fair program. So that's just a comment more than anything. Thank you.
I'd be more than willing to talk to you about that. And we're really trying to expand our partnerships with other, organizations, other nonprofits, community colleges. So anytime you're ready, be fine.
Vice President Mason.
Thank you. Dr. Brown and Ms. Groves, thank you both for your presentations. Dr. Brown, the career fair, that looked pretty exciting and the weather was in your favor, so that was also a great thing. I wanted to touch a little bit on enforcement. I was surprised not to see any recommendations on how to address that. And I think my surprise is more or less a result of complaints I'm hearing in the communities about businesses, illegal operations along Crenshaw Boulevard in South Los Angeles and Western Avenue in South Los Angeles, and how we see power being turned off, and the next thing you know, a week or so later, the power is back on, or they have some other source of power, and those shops are operating again. So I am just wondering where enforcement is in terms of discussion and ramping things up once additional funding is received, because not only is it a threat to the profit margins of the social equity applicants and all the other dispensaries as well, I won't exclude anyone from that, but it's a public safety concern. They're operating illegally, sometimes in older buildings. The wiring may not be up to code. The next thing you know, you have a fire. And our climate is extremely dry, so the fire could spread like wildfire. And then we have a disaster. So hoping something can be done to prevent all of that from happening and clamp down on these guys who are out here doing what they know they shouldn't be doing, but since they think no one is watching, they do it.
I appreciate that, Commissioner Mason. Enforcement and compliance is not part of my wheelhouse on my side of the house. Rocky Wilds handles our enforcement and compliance, and maybe Jason wants to speak to that. That's not a part of my purview.
Yeah.
So Jason, you want to talk about the enforcement initiatives that we are building out?
Yeah, I can speak to that. So DCR is firewalled from unlicensed enforcement. We have no authority or power to deal with unlicensed businesses.
Mm-hmm.
As complaints come in through the complaint portal, we triage between things associated with a licensee or an applicant, which do fall under DCR's purview, and everything else goes to LAPD. If LAPD, DWP, Building and Safety, Fire, City Attorney are going to take an enforcement action, they may or may not reach out to the department before they take the action. For utility disconnects, they may ask us to verify that a license hasn't been issued at the location to the business that they believe is operating there prior to taking the action, but they're not required to do that. As part of the mayor's proposed budget, he did include ongoing funding for the padlock ordinance, which was implemented earlier this year. Building and Safety is the lead agency, and their vendors go out and padlock a location. Once they've gotten to that point in the progressive discipline model. The city attorney has not received any new resources, and as part of their budget hearing on Tuesday, they were mentioning that some of the unlicensed activity dropped during the pandemic, but now that things are starting to open back up and people are getting back to their normal lives, they're starting to see more unlicensed businesses popping back up, and it's been raised. But ultimately, we propose that the city put an additional $10 million towards unlicensed commercial cannabis enforcement, which would basically double the resources available to fire, LAPD, DBS, city attorney to address this issue that we know is a big issue, especially for our licensees and our prospective licensees. And we fully support that request. And I earmarking some of the new cannabis tax revenue to help ensure that enforcement is funded citywide, so that the people who have the power to stop the unlicensed businesses have the resources to ensure that they are stopped and they don't pop back up. But we are on the fringe of kind of just verified information for those agencies. We don't actually have the authority to do anything about it, but we fully support the citywide cannabis enforcement, and the director is willing to step to the table and propose solutions to address some of these issues. Rocky's unit, even though it's compliance and enforcement, it's compliance and enforcement of applicants and licensees. As I mentioned, we get complaints about our licensees and our applicants, and her new unit's going to be going out and investigating those complaints to determine whether or not a violation occurred. She does compliance inspections that are required as part of the renewal process. And then, of course, if there is non-compliance, they would be cited for a notice of violation, and then it becomes an enforcement matter and follow up through her unit. If Rocky is in the meeting and available to talk, she's more than welcome to kind of talk about what her unit does and how we will liaise with LAPD and other enforcement agencies based on information.
Hi, good afternoon, Commissioner. Sorry, can you hear me?
Hang on, Rocky, before you go, I have Jason, you made a comment and I wanted to ask a question. You said the department recommended that a certain amount of the cannabis tax revenue goes towards enforcement. Does that mean that within the ordinance itself, a certain percentage of tax revenue is not allocated towards enforcement?
No. So generally, unrestricted general fund revenue, which commercial cannabis taxes are appropriated on an annual basis.
Right.
And we know that the current level of enforcement funding is insufficient and is not keeping the unlicensed businesses at bay. Therefore, we recommended that they double that budget so that folks can expand how they take the enforcement actions and hopefully reduce the number of unlicensed businesses operating. And because we're trying to drive consumers away from unlicensed businesses to the regulated marketplace, we would hopefully see a corresponding uptick in tax revenue. And if we captured just 10 to 15% of the activity that's out there from unlicensed businesses, it would more than pay for the $10 million to actually go to reducing that activity.
Thank you.
Sorry, Rocky, turn it back over to you.
Thanks, Jason. Good afternoon, commissioners. I was actually at a cannabis task force enforcement meeting with the mayor's office. And so I just got back and caught, some of what Jason was saying. Not much more to add, just like you said, we don't really have a role with the illicit or unauthorized, cannabis market. We do our daily conversations with PD, with the WP, fire, and, we assist as much as we can because the code does require us to verify if a location is unauthorized. My staff, we triage our complaint portal daily, hourly, to make sure that anything, any complaints about illegal activity is routed to the appropriate LAPD division, and then they take the lead. And like Jason said, they have a number of tools in their toolbox that they can use to try to shut these, illegal dispensaries down. But, in this meeting that I just came from, they have significantly, I know it doesn't seem like that. If you're looking in your own neighborhood, you have one or two, but the city as a whole has made a lot of progress as far as shutting down a lot of these, illegal shops, just by, with the new ordinance, the padlock ordinance, and they have the search warrants, and they have, the utility disconnections. And eventually, a lot of these locations, if they have had a utility disconnection, they won't be able to go through the licensing process with us. So, trying to discourage folks from, the engaging in illegal activity. And, some of the other things, just if I can just add, that we're doing in our department is we've actually started coordinating with the county and also with the state. My team met with the investigators at the state level so that, we are using each other's resources and, skill sets and work together, so hopefully all this will, we'll see the fruits of all this coordination and, a lot of meetings, a lot of strategies to try to tackle, all this illegal activity out there. But like Jason said, there's little jurisdiction, little more that we can do, not much more that we can do.
Thank you, Rocky.
Anyone else? Yeah, if I might add to this discussion on enforcement, I do think it's worth emphasizing. I get a lot of questions about enforcement. It is an issue, not just this city, but really in virtually every legal market there is. But we do have an issue here in Los Angeles, and it is making lives difficult for our licensees, and so. But I do want to emphasize that the jurisdiction of our department, we can only regulate actual license holders. And so I want to make sure that that is clear to those that are listening. I do think it's worthwhile, and I can work with staff on this, but perhaps we can invite some of the folks that are actively involved with the enforcement, so we can get an update, and so that the public can also know the efforts and what successes that we as a city are achieving with regard to the illicit market. I think it's important that we get the message out that things are happening. We are making progress, and we are getting better. And so we could talk about that for a future agenda item. Again, I want to thank you, Dr. Brown, Paula as well, for your presentation today. Very informative. Love the video. And it's clear that we are making a difference, and hopefully we can continue to get the resources and get those resources deployed to those that need it the most, so that we can have a thriving social equity program and infrastructure for years to come. So I want to thank everybody for their time today. This meeting is now adjourned. The time now is 4:13 p.m. Thank you very much.
You're welcome.